Professor Irwin Cotler. So we are going to ask you to have your talk. Before you start, so he's the chair of the Raoul Wallenberg Center for Human Rights and the emeritus professor of McGill University. And he's the former Ministry of Justice and Attorney General of Canada. And he's a long-term member of Parliament and a human rights lawyer. And he is the one behind Magnitsky laws in Canada and elsewhere. So without further ado, Professor Cotler, please.
Thank you for those kind words of introduction. I'm delighted to participate in this Magnitsky Forum in Japan, a great Asian democracy, a sister partner in our G7, and a country with whom we as Canadians have the best of relationships between countries and between peoples. And I'm delighted to participate, therefore, in the common cause which brings us together today, which I take to be the struggle against the cultures of corruption and criminality and the impunity which underpin them, and the importance of global justice for Sergei Magnitsky legislation, indeed the movement itself, to bring a measure of justice for the victims and accountability for the human rights violators. I want to begin by recognizing the historical contribution of Bill Browder, the visionary and courageous architect and inspiration for global justice for Sergei Magnitsky legislation, who, in my meeting with him in the United Kingdom in the spring of 2010, inspired my own involvement in Canada and beyond. And I want to also recognize Baroness Helena Kennedy, who will be speaking after me, with whom I've worked in common cause on a variety of human rights endeavors. And we look forward to hearing her remarks, as we just heard the excellent and compelling remarks of Bill Browder. What I hope to do is to organize my remarks around two foundational themes. First, how did the Magnitsky legislation regime develop in Canada? Second, what are the lessons learned from my own involvement in Canada and engagement in the US and EU and Australia, all again, I might add, at the inspiration of Bill Browder? How did this engagement have relevance, has relevance for the situation in adopting such prospective legislation in Japan, which I might add, as Bill said, the adoption of such legislation would be critically important in this globalization of the Justice for Sergei Magnitsky movement. First, let me begin with how the Magnitsky regime developed in Canada. How was the legislation introduced? What was the process of adoption? Who were the principal actors involved? Following my meeting with Bill Browder in the spring of 2010 in the UK, as I mentioned, we began on my return to Canada with a series of initiatives, and I'll use November 2010 as a snapshot for the beginning of the movement which led to legislation in Canada. We had a series of initiatives which provide a looking glass into the chronology and content of its development. First, there was a meeting of the Foreign Affairs Subcommittee of Human Rights of the House of Commons in November 2010. Bill Browder was its principal witness. We then held a premiere documentary film showing for parliamentarians on Sergei Magnitsky, because you have to remember at that time, 2010, Sergei Magnitsky was not a household word as he is today, let alone a global movement. And so we had to engage parliamentarians in an understanding of what the Magnitsky case and cause was all about. Third, we published a series of op-eds in the Canadian newspapers, articles in order to introduce the Canadian public to the nature and purposes of such legislation. And finally, the Foreign Affairs Subcommittee of the House of Commons unanimously adopted a motion calling for justice for Sergei Magnitsky legislation, and such a motion was modeled on the American initiative in Congress at that time. 1 year later, in 2011, I introduced, and I was a member of the opposition at that time, a private member's bill titled, and I quote, "An act to condemn corruption and impunity in Russia in the case and death of Sergei Magnitsky." This was the first legislative initiative of its kind in the Canadian Parliament, but as it came from a member of the opposition, it required support from the government of the day, which was not yet forthcoming. In 2012, Boris Nemtsov, the leading Russian Democrat, came to Canada as he went to the United States to support this private member's bill, along with Vladimir Kara-Murza, leading public intellectual. And that year, we launched the Justice for Sergei Magnitsky Inter-Parliamentary Group, which led to resolutions being adopted in the Canadian Parliament and country adoption in Estonia as we continue to work with the US Congress. In 2013, the pattern of parliamentary motion adoption continued, but the focus now shifted to making representations to the Canadian government, where Bill Browder and I joined in a series of meetings with government ministers, and where we conveyed documentary evidence at the time of the criminality and corruption of 60 Russian officials. But still, our efforts with regard to get the government to move were unavailing. In 2015, we witnessed a number of dramatic developments which began to move us in the direction of the legislation. In February 2015, Boris Nemtsov, as I mentioned, the leading Russian Democrat, who was playing such an important global role in the adoption of such legislation, not only in Canada, but the US and also in Europe, was assassinated right outside the Kremlin. That assassination reverberated globally and in Canada, as he had been making a number of visits to Canada for the purpose of advancing Magnitsky legislation. In March 2015, the House of Commons in Canadian Parliament unanimously adopted a motion that I tabled calling for global justice for Sergei Magnitsky legislation, again inspired by the developments in the US, which there began first with Russia, but had become globalized, and now in Canada, similarly, the motion was for a global justice for Sergei Magnitsky legislation. Accordingly, in June, I introduced, again as a private member's bill, the Global Magnitsky Human Rights Accountability Act. And now the government of the day, the conservative government, did agree to adopt the legislation. But an election was called, it adjourned the process. Interestingly enough, during the election itself, each of the three principal political parties, the Liberals, the Conservatives, and the New Democratic Party, committed themselves to adopting such legislation if elected. The Liberal Party won the election, but the momentum for the movement for such legislation was somewhat stalled. The new foreign minister at the time was somewhat concerned with what he called a reset of relations with Russia and did not want to move to the adoption then of that legislation at that moment, though it was not legislation any longer targeting any particular country, Russia or otherwise. It was global justice for Sergei Magnitsky legislation targeting individuals. And so we had to reignite the parliamentary process in both houses of parliament, both in the House and in the Senate. I want by that to say the importance of parliament as becoming the epicenter for the adoption of such legislation. And again, we had the witness testimony of Bill Browder, of Vladimir Kara-Murza. Now Zhana Nemtsova, Boris Nemtsov's daughter, came to testify, Gary Kasparov, and a number of developing factors underpinned the momentum now towards the adoption of the legislation. The first was the involvement of civil society, the involvement of the NGO community. And I want to mention here that our Raoul Wallenberg Center for Human Rights, which I had founded upon retirement from Parliament, together with parliamentarians, developed the Raoul Wallenberg All-Party Parliamentary Caucus for Human Rights. And that caucus made the adoption of Magnitsky legislation a priority. This was in 2016. In 2017, we had a unanimous report from the House of Commons Foreign Affairs Committee calling for global justice for Sergei Magnitsky legislation. The newly appointed Foreign Minister, Chrystia Freeland, in May 2017, announced government support for Sergei Magnitsky global justice and accountability legislation. And then a dramatic development occurred. There were a succession of Russian threats emanating both from the Russian embassy in Canada and from Putin himself personally, threatening Canadian legislators that if such legislation were to be adopted, there would be retaliatory consequences. And so we convened our all-party parliamentary caucus for human rights. And we said, you know, we not only have to adopt this legislation, we have to seek to adopt it if we can unanimously in both houses of parliament to send a message to the Russians that we will not be intimidated, that we are adopting this legislation for the purpose of bringing justice to victims wherever they may be and accountability for human rights violators. And I'm delighted then at that point, the Global Justice for Sergei Magnitsky legislation, as Bill Browder mentioned, was adopted unanimously by both houses of parliament in October 2017 and was adopted immediately into law. The whole not unrelated to the resurgent global authoritarianism that was occurring internationally at the time, which mandated global justice for Sergei Magnitsky legislation. Because while Russia was a major human rights violator, it was not the only one. So was Venezuela, so was Saudi Arabia, so was China, so was Myanmar, and therefore the need for global justice for Sergei Magnitsky legislation. Let me turn now, having summarized the dynamics which led to the adoption of the legislation in the Canadian Parliament, to what are the objectives and purposes of such legislation, and what is relevance of such legislation for Japan, which is now in the process of considering that initiative. The first is to combat the pervasive culture of criminality and corruption and the impunity which underpins it. And we are seeing more and more of that, both of the criminality and corruption and the impunity. Second, to deter thereby would-be prospective violators, because if we indulge the culture of impunity, we only embolden the human rights violators. But if we sanction the human rights violators, we can deter others because they will know, as Bill Browder said, that there's a price to be paid for their corruption and criminality. Third, it allows our parliaments and our governments to make the pursuit of international justice a priority and a pillar of our human rights policy, both domestic and foreign. Fourth, it allows for the engagement not only of Parliament, but for the engagement of the important ministries involved in that process: the Ministry of Justice, the Ministry of Foreign Affairs, the Ministry of Public Security, the Ministry of Finance. You almost develop a whole of government involvement, along with, one might add, a whole of Parliament involvement. Number 5 is that we affirm thereby, through all this, the protection of the rule of law, of justice and accountability in our own countries through the use of visa bans and asset seizures, as Bill mentioned. In fact, the evidence that came before our parliamentary committee of how Magnitsky assets had been laundered in Canada was but one case study of the importance of having this comprehensive legislation. Number 6, it's important to appreciate that this legislation does not interfere with the sovereignty of any other country. In fact, we're not acting against any other country or even against any other government. Rather, we are seeking to sanction major human rights violators in whatever country that these violators are engaging in gross violations of human rights, be it extrajudicial executions, torture, massive corruption, and the like. And in effect, we are protecting our own sovereignty, be it in Canada or Japan. We are protecting our own sovereignty, our own rule of law, our own economy, and we are excluding would-be perpetrators from exercising what is in effect a privilege, namely to enter our country, to launder their assets here. And we are thereby, as I say, protecting our own economy, our own sovereignty, our own rights. Number 7, we protect thereby Canadian businesses or Japanese businesses operating abroad, for example. Magnitsky uncovered, as Bill Browder mentioned, the largest corporate tax fraud in Russian history, which was perpetrated against a UK-based entity, Hermitage Capital, headed by Bill Browder. So this type of legislation would not only protect the integrity of commerce in Canada or in Japan, but it also would protect Canadian and Japanese businessmen operating abroad. Number 8, we should appreciate that this legislation, as I mentioned, targets human rights violators, not governments or countries, targets those, as I mentioned, who engage in the widespread and systematic targeting of civilians and preventing them from entering our country and exporting that culture of corruption and criminality to our countries. Number 9, legislation does not bind the Canadian government, and Bill Browder spoke about the permissive may with regard to the US legislation rather than shall. But what it does do is it empowers the Canadian government. It allows us to be protectors of human rights and not enablers of human rights as a government and as a parliament. Finally, and reference was made to this in the conversations thus far, and most importantly, it tells the human rights defenders, the Magnitskys, not only of Russia, but the Magnitskys of China, of Myanmar, of Venezuela, of Saudi Arabia, of South Sudan. It tells them you are not alone, that we stand in solidarity with you, that we will not relent until we see that justice is done, that we secure justice for the victims of these human rights violations, and we secure accountability for the violators. And finally, where then do we go from here? And very briefly, and may I make a number of suggestions and with Japan in mind as well in particular. Number 1, we have to continue to internationalize the global justice for Sergei Magnitsky movement and secure as many participating countries as possible, as Bill mentioned, and as Bill has been a leader in that regard. As Boris Nemtsov put it before he was assassinated, the adoption of Magnitsky legislation by the EU countries would be a game changer. And that was why the adoption in December by the EU Parliament was so important. Similarly, Japan would be a crucial partner in this internationalization, not only of global justice for Sergei Magnitsky legislation, but indeed in the internationalization of this global movement. And it comes at a particularly important historical inflection moment, because we are witnessing not only a resurgent global authoritarianism, as I've described, and where regrettably Beijing's China has emerged as a major threat to what we call a rules-based international order. But we've also been witnessing the retreat of democracies, the growing assault on human rights, the assault on media freedom, the growing imprisonment of human rights defenders, political prisoners as a looking glass into this dynamic, and therefore the importance of global justice for Sergei Magnitsky movement and Japan as a central pillar in that movement for purposes of justice and accountability. And I think as Japan moves forward, one must appreciate from the Canadian experience, as I sought to outline it and elsewhere, the importance of government, parliament, civil society, stakeholders working together in common cause. And within that, I need to emphasize, certainly from the Canadian experience, the singular role of Parliament as a whole, and the parliamentary committees, both the Foreign Affairs Subcommittee on Human Rights and the Foreign Affairs Committee as a whole, both of which unanimously adopted resolutions after sustained consideration of witness testimony and study, which presaged the way for the adoption of the legislation itself. And the importance thereby of deterring, as I mentioned, would-be violators, because we must always remember that if we indulge the culture of impunity, we only embolden and enable the human rights violators. If we sanction the human rights violators, we thereby deter them as we protect our own justice system, economy, integrity of our sovereignty, and the like. And finally, with these words, I close. The adoption by Japan of this global justice for Sergei Magnitsky legislation would be a historic moment for the G7, for the community of democracies, for the for the prosecution, thereby through this legislation of would-be violators, through sanctioning them. In a word, what it would do, it would be the pursuit of justice on behalf of the victims, and it would be the pursuit of accountability for the human rights violators as a central pillar of our global justice for Sergei Magnitsky movement. Thank you.
Thank you very much for this powerful statement, Professor Cotler. We hear the message that solidarity and unanimity for going forward. The solidarity is very important for this. And when you mentioned about the trust in democracy, I recall that last year had a survey, and in a survey last year they had the lowest score for trust in democracy in the countries that they researched. So I think it comes in a very important time. There are several questions addressed to you in a pre-registration and now. So one is about the implementation. So we talk about the global Magnitsky movement, but in terms of implementation, is there any problem of equity and effectiveness of Magnitsky sanctions, especially, for example, targeting specific countries and not other countries?
Well, as I mentioned, Magnitsky sanctions are intended to sanction the violators from whatever country they come from, so that we are not targeting a particular country or a particular government. We're targeting would-be violators. At the same time, if we do look at the situation in Canada as one case study, we have sanctioned, for example, violators in Russia, in Venezuela, in South Sudan, in Saudi Arabia, and Myanmar. But notably, and Bill Browder mentioned this, we have not been, in fact, engaged in sanctions for a while, and we have not sanctioned any individuals, from China, though China has emerged as a major human rights violators. And as I'm speaking to you, several days ago, a landmark report was released with respect to the acts of genocide targeting the Uyghurs in the Xinjiang region of China, where our report, which was endorsed by over 40 scholars of genocide and international law, included Baroness Helena Kennedy, who will be following me. And this compelling report, identifies those who are involved in the organization and implementation of that policy. But thus far, though China has emerged as a major human rights violator, we haven't sanctioned any human rights violators, notwithstanding the frontal assault on the democratic movement in Hong Kong, notwithstanding the mass atrocities targeting the Uyghurs, notwithstanding the repression in Tibet and the like. Similarly, we have not targeted as yet any of the human rights violators from Khamenei's Iran. I use that term the same way I use the term Xi Jinping's China, because I want to distinguish them from the people and publics, let's say, of Iran and China, who are themselves the targets of the domestic oppression of their leaders. So I think we need in Canada to move to sanction human rights violators from whatever quarter, from whatever country they come from. I appreciate, having been a government minister as well as a parliamentarian, that geopolitical considerations enter this, that countries consider interests as well as values, that they calibrate values and interests. But I do think the nature of these major gross violations of human rights in places like China and Iran, at this point, invite us holding violators from those countries accountable, as we have with others from Russia, Venezuela, Saudi Arabia, Myanmar, and the like.
Thank you. Another question from a pre-registered questionnaire is that, do you have any specific victims group that you have in mind by having Magnitsky regime?
We don't have any specific victim group in mind. It's you might call a configuration of the violations and violators and who the targets are. So I mentioned, if I use China as a case study, then yes, we would have in mind the mass atrocities targeting the Uyghurs in the Xinjiang region of China. Yes, we would have in mind the democracy movement and its leaders that are being targeted in Hong Kong. Yes, we would have in mind in Iran those who've been targeted, the journalists, the environmentalists, the Baha'i community, the heroic human rights lawyers like Nasreen Sotoudeh, who's gone down the line in Iran on behalf of the women's movement, which is a primary target there, on behalf of journalists who have been imprisoned, on behalf of other political prisoners, until she herself became a political prisoner 2 years ago, sentenced to 38 years in prison and 148 lashes for a woman in her late 50s, a virtual death sentence. And just to link up with what Bill Browder says about the ineffectiveness, or worse, of the UN system, 2 days after that conviction, Iran was elected to the UN Women's Commission on Human Rights. So it just shines a spotlight on why Magnitsky sanctions are so important, and why the global Justice for Sergei Magnitsky movement is so important to secure justice for the victims. And I tried to name some of the victims groups, and accountability for the human rights violators.
Thank you very much, Professor Cotler. I had another question, but I think it's probably time. So maybe other questions that I have here, we can address in a panel discussion if we could. So thank you very much for this powerful statement and answering all these questions very sincerely.